Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to answer a question: how do you survive the 18 to 36 months it can take from the time you start the Social Security disability process, you file your application, until the time you actually go to a hearing and get a written hearing decision? And with delays increasing again, I'm seeing delays in some hearing offices going to 2 years or longer. It can literally be 3 years from the time you apply to the time you get a decision. Absurd, ridiculous, shameful, whatever adjective you want to use, but this is the reality we're dealing with. And of course, one of the questions I get from my clients, as well as people who watch my videos: what am I supposed to do to survive? And this is a really tough one because there's no great answers, but here are a couple of thoughts I had. One is that I think that before you apply and before you decide you're going to file for disability, really think about it. Is this something that you really want to do? Is it possible you could continue to work with some sort of a modification, maybe a different job? Again, if you're disabled and you simply can't work, you can't work. But before you go this route, realize you may be out of work for 2 or 3 years before you even get a decision. There's no guarantee you're going to win. And judges can be somewhat arbitrary in disability cases. So it's possible you could go through this whole process and still not win. So again, before you file, make sure that you've exhausted every other possibility, every medical treatment you can, every modification at work you can, to really make sure that this is what you want to do. Second thing is prepare, and that is, as best you can, save up your money. And that means that if you realize that things are not going well and you're having more difficulty working and you see medical storm clouds on the horizon where you're going to have additional medical treatment, change your lifestyle. Save up your money. Put money away as much as you possibly can. Prepare your relatives and friends. See if they'll help you. See if you can reduce your standard of living so that you have some place to stay. You're not necessarily, maybe you have to give up your house or your apartment and go live with relatives. Unpleasant to think about it, but again, you want to be prepared. The time to think about that is not when you're in foreclosure. And I think that, when I hear people that say to me, I filed for disability, I had no idea it was going to take this long, and I'm about to lose my house. Again, unfortunately, I got to tell you, it's going to take that long. And if you're assuming that you're going to get benefits awarded to you within 6 months or a year of your filing, that's many cases wishful thinking, even for the best cases. So don't assume you're going to win. So again, go ahead and make arrangements with friends and family members to try to find a place to live. Third thing is, be very careful about raiding retirement money. In many cases, you can file bankruptcy on medical bills and other expenses and preserve your retirement money. And certainly in SSDI cases, having retirement money is not going to be a problem. So I've again talked to people that they were filing for disability. They had, let's say, $50,000 or $60,000 or more in a retirement plan, 401k or IRA, and they were starting to get collection phone calls, and it was driving them crazy. So they decided, I'm going to go ahead and take the money out, deal with the tax penalty, and get these bills paid. And what ended up happening was they paid the bills, yes, but they ended up having more bills, and now they have no retirement money. So a better solution in that situation would be to let the bills accrue, as unpleasant as that may sound. At some point when the bills have stopped accruing, or you're at a certain point where you're not working anymore, you can file bankruptcy on those. Again, when you're judgment proof, nobody can come after your Social Security money. So if that's what your source of income is, you could owe millions of dollars, and no one's going to be able to get that in a civil lawsuit from a medical provider. So maybe the thing to do would be to go through the process, and then once you are approved and eligible for Medicare, then at that point perhaps file bankruptcy to get rid of all this other debt. That's just a strategy, but again, something to talk to your lawyer about. While you're in the process, you can sometimes get the case expedited by contacting your U.S. senator or U.S. representative. They a lot of times will have people in their office who can make a phone call. That can sometimes speed up the process. We can also sometimes do what they call a dire need to speed up the process, although again, you need to have some sort of documentation like a foreclosure notice or notice of repossession. That can sometimes work, although again, it's overused. A lot of people do that. That can be some way to speed up the process and to help avoid really get you out of survival mode when you're waiting for these long delays. The other thing that I try to do is, as soon as I have a judge assigned or a hearing officer assigned, I'll do an on-the-record request. Many times that can shave a year or even more off the wait. So again, if your lawyer is willing to do that, have him or her write an on-the-record request, and that may speed up the process a little bit and allow you to live a little more dignity, whether it's with a friend or on your own. But again, that may help you survive a little bit as well. So those are just some ideas. My big picture here would be talk to your lawyer about it. And again, we're not going to have great answers necessarily, but before you make any decisions like rating a 401k or retirement plan or filing bankruptcy in the middle of your case, talk to your lawyer about it and see whether or not it makes sense to wait. Again, I've had cases where I will write letters to the creditors saying my client's judgment proof, we're waiting for disability, leave him or her alone under the Fair Debt Collection Practices Act. You can write them a letter and say leave him alone, leave her alone, because again, they're judgment proof and you have nothing to give. So there's some ways to maybe survive a little bit better while you're waiting for your hearing. But again, it's a long road, no great answers here, but certainly reach out to the attorneys in your life that maybe can give you some ideas or some suggestions about your personal situation, but don't make rash decisions without talking to counsel. So I hope you found this helpful. If you did, please give it a thumbs up on YouTube and like it on Facebook, and subscribe to our YouTube channel, like our Facebook page. And if I can answer any questions for you about disability, please reach out to me. Jonathan Ginsberg here, and I'll talk to you next time. Thanks a lot.